Hi, good morning. This is Rajeshkumar. Today we are going to discuss about Russian for misrepresentation. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer. A person may be able to resign a contract if they were induced to enter that contract in reliance upon a misleading statement. However, the rules governing such rescissions are unnecessarily complex. We have to discuss on this area. Rescission is a remedy available when a party has been induced to enter into a contract based on a misrepresentation, which is a false statement of fact made by one party to another intending to induce the other party to enter into a contract. Russian aims to restore the parties to their pre-contractual positions, effectively undoing the contract. The remedy of Russian for misrepresentation, though essential, has been criticized for being unnecessarily complex due to its strict requirement and various limitations. This analysis will focus on rules governing rescissions for misrepresentation. What is the scope and purpose of rescission? The rescission aims to restore the parties to their pre-contractual positions after a misrepresentation has induced a contract. Unlike termination for breach, which focus on contract performance issues, rescission addresses the situations where one party relied on a misleading statement. The equitable nature of rescission makes it subject to judicial discretion and various limits, reflecting the need to balance a fairness for both the parties. However, these limits also introduce complexities that can sometimes restrict the remedy's accessibility, triggering rescissions, inducements, and misrepresentation. For rescissions to be available, the misled party must prove that there was a misrepresentation, means a false statement of fact. The misrepresentation induced them to enter into the contract. In Payman versus Lanjoni in 1985 case, it was held that a misrepresentation must have materially influenced the decision to enter into the contract, even it even if it was not the sole reason. This shows that threshold for proving the inducement is not overly stringent, and the misrepresentation need only be one of the reasons the contract was formed. The effect of rescission. When a contract is rescinded, it is treated as if it never existed. The parties are restored to their pre-contractual positions. This involves the return of the party or the money exchanged under the contract. Rescission is an equitable remedy and thus discretionary, meaning the courts has the flexibility to refuse rescission in certain circumstances, particularly where it would be unfair or impossible to restore the parties to their original positions. Let's look into the limits on rescissions and bar to rescissions. While rescission is a flexible remedy, its availability is constrained by various bars, which have been criticized for introducing unnecessary complexity. First one is affirmation. If the misled party, after discovering the misrepresentation, affirms the contract by continuing with it, they lose the right to resign. In Long versus Lloyd case in 1958, the buyer of a defective lorry lost the right to resign after continuing to use the vehicle despite knowing of its defects. This bar reflected the need for finality in contract law, but it can lead to unfair outcomes if a party affirms the contract undue duress and without fulfilling the understanding the consequences. In other words, if a party becomes aware of the misrepresentation and despite these continues with the contract, they may lose the right to resign the contract. Long versus Lloyd illustrate this bar where a buyer affirmed a contract after knowing of defects, losing the rights to resign. The idea of affirmation adds complexity because determining whether actions constitute affirmation can depend on subjective interpretation of contract. creating uncertainty for the parties seeking to resign. Let's move on to the next one. The lapse of time. A party may seek a rescission promptly upon discovering the misrepresentation. In Leaf versus International Galleries in 1950, the buyer of a painting attempted to resign the contract 5 years after purchase. When he learned that painting was not by the artist he had been told, the court held that delay was too long and barring rescission. This rule is particularly harsh in case of innocent misrepresentation, where the misled party may not realize the extent of the misrepresentation until much later. The rigid application of this rule introduces unnecessary complexities as it does not always account for the context in which the misrepresentation was discovered. In other words, a claim for the rescission may be barred if a substantial amount of time has passed since the contract formation. In Lee versus International Galleries, the plaintiff could not resign 5 years after purchasing a painting due to an unreasonable delay, even though he only later discovered the misrepresentation. This case highlights the difficulty in determining the reasonable time for rescission, especially in instances of innocent or negligent misrepresentation where the harm may not be immediately obvious. Let's move on to impossibility of restitution. The principle of restitutio in integrum requires that both parties be restored to the original position for the rescission to occur. When the restitution is impossible, rescission may be barred. In Wrangler versus New Cumbria Passport Co. case, the court allowed rescissions with some allowances, provided that substantial justice could still be achieved. However, modern cases often find that the inability to achieve full restitution bars rescissions, complicating the remedy's application and raising questions about its particularity, about its practicality. In other words, rescissions require that both parties be able to restore what they received under the contract, meaning the parties must return to their pre-contract position. If this is impossible, rescission will be barred. In Wrangler versus New Sambrio Passport Co. in 1978, the partial rescission was allowed because the passport mine had been worked, but the court do not always take such a flexible approach. The requirement for the full restitution complicate the rescissions, particularly in contracts involving the sale of perishable goods or services. The rule imposes an unrealistic expectation that parties can always undo the contract entirely, when in some cases a more flexible approach to restitution might be appropriate. Let's move on to the last point, intervention of the third party rights. If the third parties have intervened, such a bona fide purchaser acquiring the misrepresentation asset, decision may be barred to protect these new interests. This was established in the Car and Universal Finance versus Caldwell, where a third party interest limited the remedy or the rescission. In other words, if the subject matter of the contract has passed to a bona fide third party before rescission, the misled party loses the right to resign. In the Carr versus and the Universal Finance versus Caldwell case in 1965, the claimant resigned the contract for the sale of a car by notifying the police after discovering the fraud, even though the car had been sold to a third party. The court held that prompt action could still be preserve the right to resign. However, if the third party had already acquired the car before the notification, rescission would have been impossible. While protecting the third party rights is important for a commercial certainty, this rule can unfairly penalize the misled party if they acted quickly but were unable to prevent the transfer to a third party right. So, what are the complexities added by Section 2 of the Misrepresentation Act 1967? Section 2.2 of Misrepresentation Act 1967 permits the court to award damage in lieu of rescission for non-fraudulent misrepresentation if the rescission itself would be inequitable. For instance, in Salt versus Sandstone case in 2015, the Court of Appeal emphasized that Damage could be awarded as a substitute only if the Russian was initially available but subsequently rendered impractical. This section introduces the flexibility but the court discretion in determining what is equitable adds another layer of uncertainty as each case requires balancing the nature of the misrepresentation and the impact of Russian on both the parties. In other words, the Section 22 of Misrepresentation Act 1967 limits the availability of Russian for the non-fraudulent misrepresentation by giving the court the discretion to award the damages in lieu of rescission. This provision was designed to provide a fairer outcome when the full rescission would be unjust, but it adds a layer of complexity. In the Salt 2015 case, the court held the damages under the Section 22 could not be awarded if the right to resign had already been lost, suggesting that Section 22 does not apply where full rescission is impossible. This ruling narrows the scope of Section 22 and adds complexity by limiting when the court can award damages instead of a rescission. What are the critics of complexity of Russian rules? These rules governing the Russian will necessitate to balance fairness have been criticized for their complexity. The first one is affirmation and time limits. The strict application of this bar can lead to unjust outcomes, especially when the parties affirms the contracts without fully understanding the misrepresentation or the implication of delay. A more flexible approach, allowing the court to consider the broader context of the affirmation and delay could alleviate this issue. The restitution and requirements. The requirement for the full restitution can be too rigid in modern commercial context where partial restitution would suffice. This creates the complexity in cases where a strict return to the status quo ante is impossible. Interaction with Section 22 of the Misrepresentation Act 1967, while the Section 22 provides an alternative to rescission, the discretionary nature of awarding the damages can introduce uncertainty. The interplay between the rescission and the damages under Section 22 often requires nuanced legal argument, adding further layers of complexity to the process. What about judicial discretions? The equitable nature of decisions requiring the individualized judgment about fairness and add variability and unpredictability. The requirements such as restitutio in integrum and the lack of third-party rights make the rescission impractical in modern commerce. Inconsistent application. The cases like Salt versus Stanton demonstrate that Section 22 of the Misrepresentation Act while intended to simply relieve, may add complexities when courts determine when damages rather than rescission should be applied. To conclude, rescissions for misrepresentation provides an essential remedy but is encumbered by the complex rules and limitations, making its application challenging. The discretionary and equitable nature of rescission introduces significant uncertainty, while the requirement like restitutio in integrum and the time bars further complicates the access to the remedy. Section 22 of the Misrepresentation Act, while intended to offer flexibility, has added another layer of complexity. This framework, while aiming to balance the fairness, risks becoming unduly complex and inaccessible for misrepresented parties, suggesting a need for reform or the simplification. The rules governing the decision for misrepresentation are unduly complex, particularly due to the strict applications of laws such as affirmation, lapse of time, restitutions, and the protection of third-party rights. While these rules serve to balance the fairness and uncertainty, they sometimes result in unjust outcomes or unnecessary procedural hurdles. Section 22 of Misrepresentation Act 1967 provides some flexibility, but its limited scope and discretionary nature also add complexity. Overall, the complexity of the rules surrounding the Russian could be simplified, particularly by adopting a more contextual and flexible approach to bars like time limits and restitutions, thereby ensuring that the misled parties have fair access to the remedy. Thank you.